Hello, everyone, and welcome to day two of our live webinar on the new $100,000 H-1B proclamation. We are live every day this week to answer your pressing questions on this. Today, we are joined by partner and attorney Gladys Gervacio from our headquarters in Los Angeles and partner and attorney Navdeep Meamber from our offices in Santa Clara, California. If you are watching this, please comment your questions below or email us at info@chuk.com. Just a reminder that this conversation is for informational purposes only. Welcome today, Navdeep and Gladys. Thank you for being here.
Thank you for having us.
So I want to get into a little bit more about what legal authority this proclamation relies on. Yesterday we covered the basics. So Gladys, today, can you walk us through what legal authority this proclamation relies on, just so that we can get a better understanding of all this?
Sure. So the proclamation cites the president's authority under the Immigration and Nationality Act to regulate entry of non-citizens, specifically sections 212F and 215A of the Immigration and Nationality Act. So the government is framing this as an entry restriction, not a standard USCIS user fee. Historically, this authority has been used for entry restrictions, but not fees. That's why some legal observers expect litigation, but until a court rules otherwise, employers would have to comply.
Can you tell us a little bit about the kinds of legal challenges that we might see?
Well, lawsuits could argue that the fees exceed the president's authority, and that using those sections of the INA to condition entry into the US based on a large fee payment exceeds presidential authority. It can also be argued that it conflicts with the role of Congress to set immigration fees. On the other hand, the government will argue that it's within the president's power to regulate conditions of entry of non-citizens in the national interest. So courts will ultimately decide, but for now, employers must prepare to comply.
Could this apply to petitions that were already filed before the effective date, or is this only for petitions filed after?
So no, it can't be applied to those filed before the effective date. The USCIS memo states that the 100,000 fee requirement applies to petitions filed after 12:01 a.m. on September 21st. It does not apply to beneficiaries of petitions filed before that time, approved petitions, or current H-1B visa holders. USCIS also says it does not impact current H-1B visa holders' ability to travel. The CBP memo echoes this as well, and that it's applied prospectively.
Wow, really good to know. Can you tell us a little bit about how we might expect USCIS to implement this fee in practice? What is that going to look like?
So the proclamation directs the Department of Homeland Security and USCIS to restrict decisions on petitions for beneficiaries outside the US unless the 100,000 fee has been paid. And employers must obtain or retain proof of payment before filing. And the Department of State must verify receipt during visa processing. So likely there would be updates to the Form I-129 filing instructions and the fee schedules. Employers may need to provide proof of payment at the time of filing. It may take time for USCIS to fully operationalize this process.
Wow, thank you for covering all of that. I want to get into a little bit about what things will look like from an employer point of view and what HR needs to consider during this. So, Navdeep, can you tell me a little bit about how does this interact with prevailing wage rules and compensation planning?
So from this point, like employers have to still continue to meet their prevailing wages and actual wages, whatever they listed in the LCA. So, when we do an LCA for H-1B, there's already an offered wage, which the employer says they're going to pay their employees. So this has to be still met, and you cannot add that 100,000 to that, or they cannot even deduct that from the employee's wage. Employees will need to budget this 100,000 when they are doing a new H-1B, and they cannot take it from the employee or deduct it from their wages. So it's a very critical thing to consider, and which we see will be ultimately impacting how the H-1Bs are being filed.
Yeah, can you tell us what impact this can also have on job changes, promotions, or relocations, for example?
So, it will depend on if the employee for the who H-1B is being filed is in the US or they're outside the US. So when we file H-1B for someone who is in the US, it's like a renewal or amendment or a transfer. So like, yeah, they could be promoted, they could be a change of employer, but if they're in the US, this is not going to impact them. The employees do not have to pay this 100,000 fee for that, so they are fine. But if the employee is outside the US and they're filing it as a new employment or outside the US, then they have to pay that fee. So yes, this is going to impact only if they're going to be outside the US, but for any relocations, transfers, renewals, promotions within the US, it's not going to be an impact as of now.
Okay, good to know. What about how might smaller employers be affected by this compared to larger companies? Do we have any insight on what that's going to look like?
So yes, that is very critical. So we can see that larger companies, they will be able to absorb the cost. While smaller businesses who are like staffing companies or like who really like work at a smaller scale, startups especially, it's going to be very hard for them to pay these additional fees. So if someone's salary is, let's say, 75,000, and on top of that they have to pay 100,000, so this will be like 100,000 plus 75,000. This is like very additional cost which they may not be able to afford, especially startups. So this could influence how the hiring practices go across the industries and how there's going to be a wide gap hiring by the big corporations versus the startups.
Wow, yeah, that we'll have to see how that plays out. So, what about some exceptions to this proclamation? Do we have any insight on what that looks like?
So as of now, as per the proclamation, that it specifically excludes any individual applicants or all individual employed by a company or individuals working in a specific industry if they determine that it is the national interest of the US. And that exemption would not pose a threat to the security and welfare of the US, right? So this has to be, I would say, examined case by case basis. As we remember, during COVID, we had situations like, medical professionals, they were exempted. So we have to get more details on this by the Department of State or USCIS, but we see that there would be certain exemptions on these lines.
Wow, thank you for sharing that with us. I want to dive a little bit more into how this impacts workers. Gladys, can you tell us how should current H-1B workers think about extensions in light of this?
So H-1B employees in the US should, I would say, immediately discuss timelines with their employers early on. As employers, they may evaluate whether to file the extensions promptly or wait a little bit, and also consider alternatives such as starting the green card process sooner than later.
Yeah, that's a great point. There are other options out there available for workers. So if an H-1B worker changes employers, how will the new fee apply?
Well, I think the Navdeep touched on this one, that a change of employer in the US where the beneficiary remains in lawful H-1B status, they're not expressly covered in the proclamation and the memo. So unless instructed otherwise by USCIS, it appears that they are exempt from the 100,000.
Thank you for clarifying that. And could this influence employers' decisions on retaining H-1B workers altogether?
Possibly, Arianna, because employers would now have to carefully evaluate their H-1B new hires abroad, extensions or change of employers or change of status in the US are less impacted under the current USCIS guidance. And it's important to note too that there are broader enforcement initiatives. For example, the Department of Labor announced the Project Firewall. And then there are wage-related initiatives, which were also announced alongside this proclamation. And all these may influence an employer's strategy in terms of hiring workers.
Wow, a lot of things that are to be considered here. So can you tell us a little bit about what the risks look like that a worker might face if an employer maybe refuses to pay the fee or withdraws sponsorship even?
Well, for H-1B beneficiaries abroad or those abroad, consulates, of course, can refuse to issue the visas without the payment. And obviously, they can't enter the US without that. And then for workers already in the US, current USCIS guidance says existing status isn't affected by the proclamation. So the standard H-1B rules on employer withdrawal of the petition and the discretionary 60-day grace period may still apply.
Wow. Okay. Thank you for sharing all of that with us. I want to shift a little bit into how this affects industries in particular and just the economy in general. Navdeep, can you tell us, from your point of view, what industries are likely to feel the strongest effects?
So, Arianna, I think the sectors which have a high concentration of H-1B workers, such as technology, research, healthcare, these would be impacted. I know, like our firm handles a lot of technology, IT IT industry. So these are going to be, I can see when the H-1B cap comes next year, some of my clients may not be able to afford to pay this 100,000. So they may not file H-1Bs anymore, cap especially. So the actual impact, I would say, will vary depending on the reliant employer is on the visa category. So it could be depending on that.
Great insights there. Could this change maybe encourage employers to consider offshore or remote work arrangements? What do you think on that?
Yeah, it's possible, very much. We already see the work is going offshore, with all the restrictions which we had even before this came out. So some employers may evaluate global workforce strategy, and if the cost of US sponsorship is becoming too high for them, then they may go offshore or they may go to other countries. They also may prioritize retaining talent in the US despite the higher fees. So it depends what their needs are, how big or small the client is. But I can certainly see that this could go offshore, yes.
Yeah, that would make sense. Can you talk about the impact this might have on universities or international students, if any? What are your thoughts on that?
So we know universities often sponsor H-1Bs for researchers and for faculties, and international students also rely a lot on H-1B. After they study, they do their master's or undergrad, then they do OPT, and then they want to go on H-1B if they want to stay in the US. So this will impact them and they will need it. But specifically, we haven't got any guidance on which pertains to universities, but we are going to hopefully hear further on this. It will help, I would say, students in certain extent. If they're in the US, they are on OPT or student visa, and if they're going to do a change of status to H-1B cap, they're not going to be impacted, so that's the positive for them. Because as compared to them, if there's someone who's outside the US, they will be impacted. So students may not be impacted because if they're going to do change of status here.
Wow, good to know. And as you mentioned, we are getting a lot of information, as time goes on. So if you are watching this and interested in getting updates, please sign up for our newsletter. You can go to our website, chugh.com, CHUGH. You can sign up for our newsletter. We have accounting newsletters, immigration newsletters, legal newsletters. So feel free to go ahead and sign up. We will give you the latest updates as well. So I want to go into a little bit about the alternative pathways and how things look from a compliance point of view. Gladys, if you want to help me out here, what alternative visa options should employers evaluate now that this new proclamation is in place?
Well, options include the L1 intercompany transfers, so the L1A for the managers and executives, and the L1B for those with specialized knowledge. But of course, this would apply to multinational companies, not the smaller companies. And then you have the O1 individuals with extraordinary ability, the TN visas for Canadians and Mexican nationals, the e-visas for treaty investors or traders. So each visa type would have specific eligibility requirements. Not every case will qualify, so we would encourage you to, of course, contact your trusted immigration professional for assessing eligibility for those visa categories.
Yes, absolutely. As you mentioned, there are lots of options. If you are wondering about the visa options out there, feel free to reach out to us or comment below. We're happy to guide you on that. So, could earlier green card sponsorship become more common as a strategy?
Say yes. I mean, employers would want to start their perm process sooner to avoid multiple H-1B extensions. And they want to reduce reliance on the H-1B program in the long term. And just overall, because of the delayed processing times with the Department of Labor on the perm processing, I mean, it's just advisable to start the green card process sooner.
And how would you say multinational companies should adjust their mobility planning after this?
Well, these companies may evaluate the balance between placing workers in the US versus their entities abroad. So, of course, it would involve compliance with labor laws, tax obligations, and business needs. These will all be factored into making that decision.
Thank you, Gladys. And looking forward, Navdeep, can you tell us what developments should employers and employees monitor over the next 30 to 60 days? What do we need to be on top of?
I think we have to glue to these all different social sites to see what updates are coming from the government. And that's how we found out last time, right? So first of all, I think the employers should review whether the H-1Bs they're filing are for people who are in the US or they're outside the US, that's very critical because that will determine the fees applies or not. I mean, we're talking about H-1B cap, which will happen in future next year. But even outside the H-1B cap, let's say for someone, when one of the employee left the US and they're currently in India or other country, wherever they are from, right? And they have to do H-1B for them. And then this will like the fee may apply to them because they are not here. So even if it's not a cap. So this is very critical to see first the H-1B which is being filed, the beneficiary is currently present in the US or the outside the US. And then besides that, I think the employers have to work closely with their immigration providers because we all are trying to monitor the key updates as they're happening from USCIS, from the Department of State. We've got all these memos coming out from CBP, from Department of State, from USCIS. So they should be monitoring that as well. Sign up for the alerts from them. They should be coming to them. So this will like really, we are waiting some further instructions and clarifications. So that will shape like how the rule is really applied in practicality. So that's what now we have all these updates, but we now need to see how this is going to be really applied. So work closely with your immigration providers.
Absolutely, yes. Make sure you are asking all the questions you have, and if you need additional help, we're always here to assist. Thank you so much, Navdeep. Gladys, one more question. What role can professional associations and industry groups play in this? What organizations should we be looking to?
Right, so there are employer coalitions, industry groups, professional organizations such as the American Immigration Lawyers Association. So all these groups provide guidance to the public, they submit feedback to government agencies, and in some cases pursue litigation against the government. I think it just benefits everyone, employers, the employees, by staying engaged with these groups for timely updates.
Absolutely. Thank you so much, Gladys and Navdeep, for taking the time today to answer all of our questions on this topic. We will be live tomorrow, so if you do have additional questions, feel free to email us at info@trig.com or join us tomorrow and ask us in the comments. That is all we have time for today, so thank you everyone for joining us today. A special thank you to you, Gladys and Navdeep. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. Sign up for our newsletter on our website. And if you have any questions or suggestions, feel free to email us anytime at info@trig.com. Let us know what topic we should cover next. And make sure to join us back here tomorrow for the continued conversation. Until next time, stay safe and take care, everyone. Thank you, Gladys and Navdeep.
Thank you.
Thank you.